And thank you to everybody who's here. Thank you for all our online participants. And I'm very happy to be here and not in Chicago this afternoon. So let's jump into our presentation today, which is optimizing your business through legal fitness. And we'll start. All right, we are going to start, he said. There we go. We'll start like all great presentations do with a very legal and lawyerly disclaimer that this is not legal advice, but it's general information. And if you have specific questions, you should talk to a legal advisor. We'll also have a disclaimer at the end. So we got you coming and going with disclaimers today. Now, that being said, let's launch into the presentation. All right, the button is being a little particular. So there we go. All right. This whole concept of legal fitness starts with this idea. A corporate entity is often referred to as a legal person because it can file a tax return, it has a tax number, it can sue or be sued in court. It's recognized as a person for legal purposes because it protects you, the shareholder or business owner, from personal liability, right? It's the corporation that would be liable for any obligation, not you personally. So I was thinking about this recently when I was trying to get back into playing basketball and being at some advanced years. I'd go out and I pulled my calf and I talked to the doctor. I'm like, what's going on? He said, well, your hamstrings are tight. And I thought, well, that's weird because it's not my hamstring, it's my calf. Then the next day it was my heel. And he said, oh yeah, now that's your calf. And then it was my back. And he said, you've got a bad core. You got to work on your core. So now I'm training like I'm going to participate in a decathlon just to go run around like an old man on a YMCA court. And you can make that analogy to your business, right? You can be great at sales, your business can be humming, but if your IP isn't protected, if you don't have the right insurance, all those things can weaken the whole. So from that standpoint, we think a legal person, the corporation, is best served when the whole body or the whole corporate person is being tended to. So today we're going to take a look at three general stages of the corporation. Its birth, which is its formation, its growth when it's out there raising capital and getting customers, and at its retirement when you reach that point where you sell the company, right? Every business owner's dream. So that's what we're going to start with, is the birth process or forming the company. Okay, so we're going to start with a brief background on the types of corporate entity. And these are just in general. These are the ones you'll see the most. We've got a corporation, and within that we have C corporations and S corporations, and we have limited liability companies and limited liability partnerships. And these are the types of companies that most business owners are going to form when they want to start doing their business. Okay, so within that we have C corporations. We'll talk about that a little bit. C corporations are typically used by larger publicly traded companies, or we'll see it a lot with startups. Venture capital firms, they want to invest in a Delaware C corporation. And the reason for that is Delaware has an established body of law. If there's ever any dispute, they can go to a Delaware court and they're in front of a judge and not a jury. So it's an easy way to make sure that the corporation will be tended to when you have a lot of shareholders and room for disputes to happen. And they also, every startup thinks that they're going to be the unicorn and they're going to have the IPO, so they want to do just like all the big companies do. They want to be a C Corp. Now, the issue with C Corps can be, though, that there's a double taxation issue. The corporation is going to file its own tax return. It'll file an 1120, and it will be taxed on its corporate income. Then if you receive non-salary revenue from the company, say you get a dividend, you're taxed on that twice. So that's the one drawback that small businesses will look at with a C Corp is they say, hey, we're taxed on the money the entity is making, and then we're taxed again on any dividends we receive. There are a couple of ways to address that, and I'm just going to mention them. It's beyond the scope of this because we could go into an entire presentation on it, but there is such a thing as qualified small business stock, where you can get up to $10 million or 10 times your basis in the stock will be exempt from a gain on sale. There's also a possibility to convert. If you have enough runway, say you're not going to sell for another 5 years and you say, oops, I'm a C Corp, I really didn't want to do that. You always have the option of converting, but you need sufficient runway to make that happen. But the double taxation issue is enough of a sort of a hindrance where a lot of companies will become S Corps instead. And the benefit of an S Corp is you're taxed as a partnership. There's no double taxation issue. The drawback to the S Corp is what's called the one class of stock rule. And that means you essentially have to pay yourselves equally as shareholders. If you're getting distributions, you all have to be paid according to the percentage that you own in the company. Or if you sell, you got to be paid according to that percentage. And there's other restrictions like corporations can't be S Corp shareholders. So sometimes those amount of restrictions cause people to go into our third formation here, which is a limited liability company. For instance, say you go out to market and you want to raise investors, and they're going to be passive members in your limited liability company, which we'll call an LLC for our purposes here today. You want to incentivize these passive investors to invest. So you say, we're going to pay you an accelerated return on the money you invest. And at that point going forward, we, the operating partners and the operating shareholders, will catch up. But we want to make sure that you get your capital back more quickly. You couldn't do that with an S Corp. Conversely, if you were a lot of commercial real estate companies would say, we're a shareholder, but we are also the operator, we're the developer, so we want to pay ourselves a little bit more because of all the work we do. Again, you couldn't do that with an S Corp, which is why a lot of commercial real estate companies and developers will use a limited liability partnership instead. So now that you have your choice of entity decided, you then move on to how are you going to govern yourself? This, I think, is one of the most overlooked and one of the most important things we can take away from here today. Because your shareholder agreement, if you're a corporation, or your operating agreement, if you're an LLC, it's going to govern your relations between each other. There are probably thousands of lawsuits in San Diego right now where shareholders are suing each other because, among other things, they had an agreement which didn't cover all the terrain it needed to, and they got into a dispute and they didn't know how to get out of it. So how is the company going to be managed? Will it be managed by a board? Will you just have the shareholders vote on it? You can really do it any way you want, but the important part is to have it all in writing. And let me give you one illustration on that. So California Corporations Code on LLCs, it says the default provision is all members of your LLC have to consent to a sale or merger of the company. So say you have 5 members in your LLC and one is disgruntled, you've got a great sale out there and they're going to block it because they're mad. They just want to be difficult. They want to maybe extort you and say, pay me more to make me consent to the deal. Your operating agreement can do away with all that. Your operating agreement can say, we are going to consent to a sale by a simple majority vote. The operating agreement can trump the statute, but the problem is you've got to have that in writing. So these are the kind of important things you need to address up front. You might also put in your agreement limitations on equity holders, for instance, a non-compete to say we're not going to compete with this company we've formed with each other, intellectual property assignment, any intellectual property that we develop for the company, we're going to assign that to the company because that's where it should be. Another very important point, and again, in all caps, maybe the most often overlooked early action item on these types of agreements is a buy-sell. So what happens if, heaven forbid, somebody is to pass away or becomes permanently disabled? Or what if they just leave the company? They have a huge judgment against them. All these kind of things that brings in elements of uncertainty. We address that with what's called a buy-sell agreement. So a typical provision would say if a shareholder passes away, then the other shareholder could buy all the stock from the deceased shareholder. And you might even do that with life insurance. You can get cross-insurance policies to fund that buyout so you're not crippling your company. But addressing that up front is imperative, and a lot of people don't do it. And it leads to another common early misstep. Providing full equity to all your founders with no obligation for them to keep providing services. I've seen this so many times. You get 3 shareholders, right? You're all going to get a third, a third, and a third. And man, we're going to take this company to the top. And then one of them says 6 months later, I don't want to do this anymore. I hope you guys do great. When you sell, cut my 1/3 check and send it in the mail to me. So there's ways to deal with that. And one of them is to say, if you leave early, you may forfeit your shares or we may buy them back at a steep discount. But it's a terrible position to be in for the person who's stuck there working when the other one has hightailed it out and is still expecting to be paid full compensation for their shares. So the goals of this agreement are really to make it clear. It should be in as plain English as possible. If you're a small company, you don't need one of these 50-page agreements that is just all legalese. 15-pager might do you just fine, but make it clear, make it easy to enforce, Even if you're 50-50, there are deadlock mechanisms that you can use, which mean you're not going to be butting heads and unable to resolve things and running into court, but there's a better path. And lastly, make it relatively cheap to enforce. I personally don't love court. I like an arbitration provision. I typically write JAMS as the streamlined commercial arbitration rules because you can do it more quickly. And so long as the clients want to do it, I'd say, hey, let's make sure we get to a hearing in 60 or 90 days. So not everybody's spending attorney fees in the unlikely event that there's a dispute. All right, so you have your agreement. And now we are going to move on, he said, hopefully. All right. We're just going to take a tour back and forth. Hope you don't get whiplash. All right, so you have your agreement and now you're ready to get out there and operate. So what are some ways that you can inoculate yourself? We've said very playfully, time for your shot. This will only hurt a minute. So first things first is insurance. You know, you've all run your businesses, you've all dealt with insurance, and you probably have all seen, as I've seen, there's 10 times the amount of exclusions and exceptions as there is to coverage, right? So the most important thing is to talk to a good insurance broker right away, tell them about your business, and make sure they're getting you all the coverages that you need. For instance, our first one here, comprehensive general liability policy. It's really a misnomer because it's not that broad. It covers, for the most part, personal injury, certain types of personal injury, bodily injury, and property damage that occurs through the business. Well, that may not be enough to cover you. So there's a wealth of endorsements that you can get. So talk to your broker, tell them about your business, and ask them if is there a specific endorsement that'd be good for you. Other types of policies, E&O policy, errors and omissions. You know, generally for service companies, but doesn't have to always be. But it's your accountants, your financial advisors. If they make a mistake, you get coverage that way. A D&O policy, directors and officers. If you get sued as a director or officer of the company for some conduct on behalf of the company, well, that will get you covered. It'll get your defense fees paid for the attorneys, and it will cover a settlement or a judgment. The one item to note, though, like with all insurance policies, plenty of exclusions. Doesn't cover what I call officer-on-officer crime. When you get in a dispute and sue each other, you can't go to your D&O policy because the insurer says, hey, we want to protect you from third-party claims, not if you're arguing amongst yourselves. An EPL, an employment or employer practices liability policy. That covers you for discrimination, harassment, wrongful termination. In a very pro-employee state like California, that can be a very valuable policy for you. And finally, on the personal end, we talked about the buy-sell agreement. So you can get life insurance. Again, you can get a cross purchase where you get insurance on your partner and he gets it on you, and that helps fund it. You can have long-term disability. If you're the engine that runs your company and you run into some accident where you're disabled, you know, what happens? And long-term disability can be a way to offset that type of scenario. Other than insurance, we have regulatory compliance. You know, we live in a country that loves to regulate, so chances are your business runs into this a lot. And the important part here is to know what laws apply and to have the right expert. I work with a lot of manufacturers and distributors with consumer products, and so we sometimes have Consumer Product Safety Commission issues, right? What's your testing like? Regulatory items. I always call my attorney in DC right away and say, come on in, we need your expertise. And finally, we've got corporate policies. You know, internal policies are a good thing to have. Non-discrimination, FCPA, that's Foreign Corrupt Practices Act. We're not going to go bribe anybody overseas. AML, anti-money laundering. We're going to have mechanisms in place to prevent us from possibly participating in money laundering. So these aren't legally binding. You know, if the feds come and say you've been money laundering, you can't show them your policy and say, look, we're in the clear. But they're good optics so long as you enforce them. You know, show them to your employees, make sure they obey them. If they don't, you know, make sure they have some consequences for that. And the last thing I'll say on this slide is this area is changing pretty constantly. For instance, in the past couple months, I've started to see businesses get hit with letters from a law firm back east for violations of what they say is the Americans with Disabilities Act. And they say your website isn't set up for the visually impaired. So people who can't see can't use your website, and we're going to come sue you in Pennsylvania or Massachusetts for that, you know, but write us a check, and maybe that won't happen. So these are the kind of things that crop up. Another recent one is out-of-state internet sales. there's about 12 states that have this now, and it started in South Dakota. But they say if you sell X amount of product or services in our state online, you got to collect taxes in our state and you have to report. So again, these kind of things crop up and you got to try and stay on top of them as well as you can. All right, so the next stage here, you're up and ready to go and start doing what you do, right? You're going to run your business. Now, your business could be self-sufficient from the very get-go, or you may need to, like most people, raise some money for it. So again, we're going to talk about two chief methods of raising money here. One is offering your securities. That can be offering your stock. You could be doing convertible notes. There's a wealth of different securities that you could offer. But when you're a smaller company, you'll basically do that in what's called a private offering. You'll have a smaller circle of investors. You'll give them disclosures. For the most part, you're going to want to deal with what's called accredited investors. Those are people with net worth of $1 million or more, or they make $200,000 a year individually, or $3,000 as a couple. You want an accredited investor because if you're offering stock, and the stock laws, the federal securities laws are very broad, if you're offering it to non-accrediteds, you have to give them specific financial documentation, including audited documents. So it's just more expensive for you. So for the most part, when I'm dealing with companies, we're always going with accredited investors. We're complying with the securities laws. It's an exempt transaction if it's a private offering, but you still file some forms with the SEC or the state of California to let them know you've sold stock. And two important points to know here. When you bring in shareholders, you're taking on fiduciary duties to them. They are now part of your company. You, as the managers or officers or director of the company, have to treat them fairly. And secondly, even if it's an exempt transaction, the anti-fraud rules of the securities laws always apply. So you have to be sure they get enough information about your company that they can't say, oh, you hoodwinked me into buying your stock. And of course, the other method is we can just go and get that bank loan that they give out so freely, right? And in doing that, you're going to take on a number of covenants that are going to limit you in what you can do in your operations. And you're also going to be making financial disclosures to the bank, right? And making representations and warranties to them. And there's a lawyer in DC who's giving a lot of testimony right now. And one of the number of items he's in trouble for, Michael Cohen, is fraudulently filling out his loan applications. So those are the kind of things you got to really pay attention to while you're doing them. So now we've gotten our money, and now we want to just run the business and work it until the time to sell is here. So management, right? Have a good board and use it. Be consistent. And again, this isn't one size fit all. You may not have a board. It may be you and a partner. It may be just you. But I always think it's a good idea to do a couple things. One is, even if it's just you, have a quarterly meeting. Sit down, write out your plan, write out what you're going to do, and keep a historical record of it. And for a company with several shareholders, always a good idea to have corporate minutes. California law requires meetings every year. You might want to do it more than that. Not only is it a good historical track record for you, it's good on a sale. It shows a buyer, which is generally a bigger company, that you really minded your P's and Q's and you were attentive. And it also helps if there's ever a dispute. It's hard for somebody to rewrite history, or harder, if you've been keeping minutes all along. And you also want to have good customer agreements. The two biggest, maybe three biggest items here on your customer agreement are: set out your obligations and your duties very clearly. If you're selling a product, what is your specific warranty? And you probably want to make that warranty as narrow as possible. So don't let the agreement be ambiguous and have your customer or client come back and say you owe them things that you really don't. You also want to talk about indemnity. So indemnity is if there's a third-party claim against, say, your customer, and it's your fault, you would satisfy that claim by paying for their attorney or paying any judgment. And vice versa. If you got sued because of something your customer did, they would indemnify you. That really needs to be narrowly drawn and tightly defined, because again, you're possibly paying attorney's fees or judgments on behalf of another party. So make sure that all makes sense. And lastly, you want to protect your IP rights. If you are basically performing services or giving goods to a customer, maybe they're putting your product into a larger product, make sure you're retaining all your IP rights so you're not inadvertently losing anything there. And so next item is licensing and taxes. This one's easy. It's like your checkup, right? Go in and get your dental cleaning twice a year. But some people forget it. File your annual report. file your taxes. When you go to sell and you have a franchise tax board delinquency, it just looks bad. You know, you go to sell and you don't have corporate minutes for 10 years, it looks bad and it makes your buyer a little bit anxious, thinking, well, how tightly did they manage this company this entire time? And lastly, your IP. We all know patents and how valuable those can be. So register what you can, but even if it's a trademark, get that on file too. You know, trademarks I think are undervalued. Your brand, if you have a good name, it becomes the symbol of what you are. Those can be very valuable. All these apps that are out there, you can hardly get patent protection on software code. So their value is really tied into their brand and their trademark. All right, we're going to move on to what we've all been waiting for, which is the sale. And we are going to move on right now. Oh, thought I had it. Sure, that'd be great. All right, golden watch time. You've gone down this whole road, you've gotten established, you've gotten money, you've been doing great business. Now comes the time for you to sell. That first bullet point we've really talked about already. Have all your financials and your corporate docs ready to go before you begin to sell. You might work with an investment banker, a broker, an outside advisor, and they might get you whipped into shape. It's not uncommon to start getting ready to sell 2 years before you even go to market, saying, I'm going to work, if I don't have a CFO, I'm going to work with an outside CFO. Make sure my financials are tight. Make sure I'm going to get the maximum value for my company. You might likely retain an investment banker or broker. So an investment banker works generally on bigger deals. They'll get an upfront retainer. They'll get a success fee on the sale. And again, that could be 2 to 4%, but we're talking about a lot of money. If it's a more of a mid-sized deal, 10 to 30 million sale, they might get up to 6 to 8% on that. And if it's a smaller sale of a couple million or less, you might work with a broker. And a broker can get up to 10%, which is a lot. What they really bring to the table is a Rolodex. I think the investment banker generally helps you more on the financial end of things and structuring, and they also have a Rolodex, but the broker is going to chiefly be there for his or her Rolodex. But when you negotiate this deal, it's going to be a really important one, right? This is the biggest deal that you're going to do in your life, probably. So it needs to be heavily negotiated, and you need to watch out for a couple things. The first one is the tail. Realize that if you're working with an investment banker or a broker, even if you break up with them, you say they're terrible, they're going to want to have a tail in place, which says if you sell within a year or so, maybe even 2, he'll try to get after the termination, they still get paid. So you want to try to put things in there that restrict that, to say, hey, maybe it's 9 months, or maybe if we terminate you for cause, you don't get anything. That's a hotly negotiated issue. Another one would be, how are you paid? Say somebody's getting 10%, broker's getting 10%. A lot of times you only get 80% of the purchase price up front. Well, now you're paying them on everything, but you're only getting 80%. So the way I like to structure it is to say, hey, you get paid when we do. Your 10% only kicks in for each amount of payment that we get. The buyer. I honestly think this might be the most important part of the sales process, period. What is the fit with the buyer? Is it going to be a strategic company, somebody in your industry, private equity firm, internal? Do you have employees who want to group together and buy? It is a one-time deal, but within that deal, you're going to have probably a year or 2 at least of indemnity obligations, which means if anything goes wrong for the company, and it's basically, they say it's your fault and it's your fault under the agreement, you're going to have to pay part of the purchase price back. And the more aggressive and the worse the fit is, the more that buyer is going to come back and try and scoop that money back from you. So you have to be comfortable with the fit. Next, we have due diligence. Do be prepared to have a grouchy CFO. A sale process could take anywhere from 3 to 9 months, depending on the size of the company. The CFO is the one who normally has to pull everything together. And it's important because most of these deals have what's called a working capital adjustment. And what that is it means on the day that you sign the agreement, you'll have a baseline for what your working capital is, and that's your current assets minus current liabilities. Then, as of the time you close, which is generally 4, 6, 8 weeks after you sell or after you sign the agreement, they're going to look at that number, and if it went down, they're going to adjust the purchase price down. If it went up, you're going to get a little more money. Well, if you're so busy and tied into doing due diligence that the company suffers, you're losing money. So you want to be as organized as you can because you still got to run your business through this entire process. And finally, the deal itself. Don't get pressured into bad terms just because you're so close to the finish line. Again, it's easy for me to say because it's not my millions of dollars that are potentially on the line, but I sometimes think pushing back and the deal you don't make may be the best one. So make sure the deal terms are what you want before you go down the road. Kyle, if we can get the next slide, please. All right, thank you. And finally, our last substantive slide here today is what type of deal will it be? You know, in general, you're looking at an asset or a stock purchase agreement, and most buyers want an asset deal for two main reasons. They want to step up in their tax basis. When they buy your assets, they want to have a better tax basis, and then they want to take depreciation on them. For instance, they can take all the goodwill that they bought for you, or from you rather, and start depreciating over 15 years. They also want to limit their liabilities. If they buy your stock, they take on all your liabilities. If they buy assets, they can really restrict what liabilities they take on. So this conversely has tax effects for you. And that's why it's very important to talk to your CPA even before you go down this road to sketch out what would an asset deal look like for me? How can we put the purchase price and allocate the purchase price to the assets that are going to minimize our tax liability? Crucial element, which some people ignore to the last minute at their peril. But if you are going to sell your company and looking to do so, talk to your CPA and start getting some models run so you can structure it and minimize those taxes. You'll be much better off if you do. The only real benefit to a stock purchase for a buyer is they don't have to go and get assignments. So if they buy your stock and you have a lease, they're generally you, the company, they step into your shoes and they don't have to get the lease assigned. Can make it a little easier for them, but for the most part, most buyers want to buy assets. Now we talked about this next one a little bit before, how the money will be paid. How much is up front? What's the escrow period? Let's talk about this for 1 minute. Most typical mid-market deals, you're going to get 80 to 90% of your purchase price up front, and 10 to 20% of that purchase price is going to be held in escrow for what they call indemnity. So you're going to make reps and warranties as the seller saying, hey, we own all the assets, we haven't violated the law, we don't have any claims against us, we've done and complied with our employment obligations. Well, if those reps and warranties, you know, we've paid taxes. If those reps and warranties are violated or if a claim's made, what they'll do is they'll take the damages out of that escrow pot, right? So if it's 20% and you've got, say, $300,000 in that 20%, and they run into a $100,000 liability, they'll take the $100,000 out of the escrow and you've got $200,000 left over. So you don't get all your money up front, and for about a year or two period, that will be held back. And again, we talked about reps and warranties. You can get reps and warranty insurance, where if there is a claim made where they say, oh, you violated that, you need to pay us out of the escrow, you can have the rep and warranty insurer pay it. The only drawback with that is it's real expensive. So it's generally used on bigger deals. And finally, in terms of indemnity, and again, that is your buyer coming back and saying, we have a monetary obligation that we think you should pay for. There are limits on that, and we talked about it. The 10 to 20% limit for any indemnity they have within that 1 or 2 year period, it's capped, whether it's 10%, 20%, another number. They can't go over that unless there's fraud. That's the general exception where if they say you actually lied actively about what you told us, then you can bust through that cap. And that goes to that reliance element. That's how buyers try to go beyond your agreed terms by saying you committed fraud and you owe us all this money. Very rarely happens, but it can happen on occasion. So, you know, and that goes back to my point about why the right buyer is a good fit, right? Hardly anybody commits outright fraud. You got to be a real heel to do so. And most companies that are playing it square won't claim fraud if they're being reasonable. It's only those really aggressive, overly aggressive companies that will do so. And that's why the good fit is key here. All right. So in summation, you know, the legal work for your company, it's really a small fraction of what you do. Hopefully it's less than 5%, honestly, because you want to get out there, you want to be playing basketball, you don't want to do all the training and sit on a trainer's table all day. But if you kind of do your regular checkups, if you're vigilant the entire time, you know, you'll keep that corporate entity healthy and you'll stay on the path to the extent you can. So again, this very trite conclusion here, eat right, floss, do all the things we don't like to do, but do it at the time rather than trying to catch up later. And I think you'll feel much better off and you'll feel much more secure as you go through with your business. Thank you. And now we'll take any questions.
It seems a lot of it was like trying to find the right fit. How do you get some guidance for that?
Do you mean right fit for a company or right fit for an advisor?
Right fit for the buyer.
Okay, great question. I think that's where a good investment banker or broker can be really helpful because they will know the deal terms and more secondarily, your attorney. I think first and foremost, it's the broker is working on the business terms and the broker has done this a number of times. Are they asking for things that are totally unreasonable? That's your first hint. If they're asking for things that are completely off the table and you don't see typically, that may be a deal that you want to pass on. So the way this works a lot of times is you'll get first a letter of intent, which is non-binding, but it will summarize the main terms of the deal. We'll pay you X amount of dollars. This is how much is up front, and here are the assets we want, and here are the liabilities we'll take on. If in that letter of intent negotiating stage, they're asking for things that are just beyond the pale, then that's the time to talk to your broker because you can just stop it right there and not even go further. Yeah. Anyone else?
What do you think is the most crucial part of evaluating kind of your company? Let's just say if you are a smaller business, you don't really have a seasoned CFO. What are some of the best steps to take for evaluation?
I mean, one thing you can do is you can go get a valuation. You can actually, and you can get them relatively cheaply, maybe for a couple $1,000s. But what's your EBITDA? You can talk to your CPA. That might be the easiest and / cheapest way to get a shortcut valuation. Talk to your CPA. What's the EBITDA? There's public material available for what multiples would be, because a lot of times if you're in a certain industry, right, whatever it is, manufacturing, EBITDA is your earnings before interest, tax, deduction, amortization. You might have a multiple of 5 or 6 times your annual EBITDA, when the economy is good. So if you can get that number from your accountant and use that multiplier, you might have a good rough hand of what your valuation is. Anyone else?
I got another question. You mentioned the importance of funding the advised sell agreement. In regards of the premiums, if let's say you have 2 owners in the company, these premiums are tax deductible for the company. Is that correct?
That is correct. That's correct. I mean, look, you can, especially when you're starting off the business, you can get a really good rate. You can get a very good premium rate. And instead of having to fund, a $500,000 or $1 million purchase, whatever it be, if it's a 50-50 owner, you can have the policy pay it, all of it, essentially. So I always advise doing that up front. Great question. Great question. It's up to you. It really is. And as long as you're both on the same page, or if everybody's on the same page, right, there's more than 2 owners, you don't have to do it right away because you might say, hey, we don't know if this is even going to go in 6 months. But as soon as it starts getting valuable, yeah, absolutely. My fear there is always, will people remember? So hopefully I've beaten that into everybody's head enough today that they will. So, registering your trademark? Yeah. Yeah. So if you use a trademark, there's 2 trademark protections under our law. One is I just use it. I start slapping my name on my product and I sell it. You have a protectable trademark and you can sue on it. You can protect it. But if you register it, which is only $275 to do, and you can, a lot of people do it themselves. I don't typically recommend that, but if you really wanted to be cost conscious, you potentially could. If you have a registered trademark, you get priority all over the country from the date you apply, not even the date you get the registration. So from the date you submit that application form, you get it. You can also seize infringing goods at customs. You can get more damages in court. It works that way for copyright too. You can have a copyright just by putting a photograph out there. You can't sue on it until you register the copyright. Yeah, and if you don't register within 90 days, you can't get attorney's fees or statutory damages. Statutory damages under trademark or copyright law are really good because damages can be hard to prove. Up to the court and say, this defendant was a bad person. It hurt us. You know, judge, what do you think we should get? It's a big benefit to have on your IP. You're welcome.
You can send multiple copyrights for photos. You can send
Yep.
hundreds on one CD, and that's one.
Yep, you can copyright every single one. You can copy it or copyright as a compilation. There's a lot of different ways to skin that cat.
Can that be done electronically? Or have to
Yes.
mail it?
You can do that electronically now. Any other questions? All right. Well, thank you very much, everybody. Appreciate your time.